What do I need to know about domestic violence restraining orders? My name is Patricia Van Haren, and I am the owner of the law office of Patricia C. Van Haren.
My name is Sandy Joaquim, and I'm an associate with the law office of Patricia Van Haren, and we are both family law attorneys.
Domestic violence restraining orders are under the jurisdiction of the family law court and are issued against someone who has a qualifying relationship with you. A qualifying relationship is a current or former spouse, someone that you are dating or used to date, someone that you've lived with or have children with, or some other close relationship.
A domestic violence restraining order can be filed at any point during the divorce. Once you file a request for a restraining order and it is granted, you are granted a temporary restraining order that lasts approximately 21 days. And then you have a hearing set for a permanent restraining order.
Domestic violence is not limited to physical abuse. It can include harassment, stalking, and emotional abuse. If there has been physical violence, it is important to also make a police report about the abuse. The police will be able to issue you an emergency protective order, which will enable you to have the time you need to file a restraining order in the family law court.
Stalking and harassment may mean numerous repeated phone calls, text messages, or emails. Someone coming to your home uninvited can also qualify. It is important to gather all this evidence and that you will need to support your case.
The request for temporary restraining order is heard on the paperwork only. You will have the chance to present evidence at the permanent restraining order hearing. The burden of proof is on the person who is seeking the restraining order. Therefore, if you have emails and text messages proving the abuse, you want to attach that to your petition for the temporary restraining order.
The restraining order is not enforceable until it is personally served. Afterwards, the alleged abuser will have the chance to respond to the restraining order. If you are granted the permanent restraining order, it could last up to 3 years or 5 years.
In the request for the restraining order, you can ask the court in the paperwork that certain orders are made regarding child custody, custody of pets, or living arrangements. For example, if the alleged abuser resides in your home, you may request that that person moves out, or you may request control over your cell phone numbers.
You may list your children or other qualifying individuals as other protected persons in your request for a restraining order.
There may be times that someone files a false restraining order against you in order to gain advantage in a divorce case. In those cases, you will want to provide evidence that the allegations against you are false. At the trial, you will be able to question the accuser and provide your own evidence as well.
If you have any questions regarding domestic violence restraining orders, please do not hesitate to shoot us an email or give us a call.